Good day, Crime Talk aficionados. A big hearing is coming up in the Bryan Kohberger matter this week. It's really the only issue in this particular case. Alec Baldwin is not getting his case dismissed. A police officer puts himself in a very embarrassing position in his patrol car's back seat.
Lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below and hit that little bell for notifications. And I'm telling you, hit the little bell. We have so many people that say, Scott, I didn't even know you were doing videos anymore. I don't get my notifications anymore. Hit the bell, please. Sometimes people say, I thought I hit the bell, but I don't get notifications. So I hit the bell. Now I get notifications. So please hit the bell for the algorithm, please. And remember, you can listen to us anytime on any of your favorite podcasting apps out there. All right, a couple of things. It's Tuesday. Yes, even though we hope you all had a long Memorial Day weekend. We hope it was a good one, obviously remembering all that have given the ultimate sacrifice for their country. We are going live tonight. A lot going on in the world to talk about for sure. Please join us 6 p.m. Mountain Time. All right, now before we get to the docket, a couple of quick notes. The defense has rested in the Chad Daybell case. The state called a couple of rebuttal witnesses basically to obviously rebut a couple of issues that the defense had brought up. Closing arguments for the Chad Daybell case will begin tomorrow morning at 8:30. You can watch it here live. We have brought you literally gavel to gavel coverage, so please join us. Now remember, rebuttal witnesses have to be very specific to rebut a certain testimony that they want to say, no, that's not what we think the testimony is or should be, and highlight that fact. A rebuttal witness doesn't get to get up and regurgitate their entire testimony. Now remember, prosecutors usually don't call any rebuttal witnesses to the defense case unless they think something has hurt the prosecution or the prosecution thinks that the defense has scored a few points. Today's witnesses mostly clarified for the prosecution, kind of some conversations. Obviously, when Chad Daybell's daughter took place, there was a conversation with a police officer. She thought it was somewhat intimidating, so they wanted to give some context to that. And then who had access to the iPads and who turned off iPads and iPhones. Well, it looks like Tammy may have turned off some of those items because, well, Chad had a Android device. So a couple of things that the prosecution wants the jury to think about. Like I said, closing arguments will take place tomorrow morning at 8:30. I have a quick court appearance, famous last words. This will only take a second. It will be quick. But if that's the case, I intend to get back here before I have to leave for another appointment and watch the closing arguments. But I assure you, I will be watching them in the car as I drive down the road to the courthouse to and fro. All right. And also the Karen Reed trial continues. We bring you that. And oh, that's right. As we do this video, the closing arguments are taking place in the case against Donald Trump in the state of New York. The only question is, since the judge doesn't normally do court on Wednesdays, is he going to do instructions today or tomorrow or wait until Thursday? Usually judges want to be very expeditious with the presentation of evidence and not waste any of the jurors' time. But this case, nobody seems to care about the jurors as far as being accommodating to their schedules. But hey, what can you do? Either way, whenever there is a verdict, we will try to bring it to you live. Obviously, there are no cameras in the courtroom as it relates to the Donald Trump case, so we'll just have to wait and see and find out at the same time was everybody else, and then get it spoon-fed to us from the people in the courtroom. All right, let's go ahead and begin the docket and open the record for May 28th, 2024. So DNA evidence will take the center stage this week in an evidence hearing in regards to the University of Idaho murder cases. Now remember, Bryan Kohberger's defense attorneys have asked for a motion to compel, and they're asking the judge to order the prosecution to hand over certain evidence in the case that obviously the defense believes that they are entitled to and that they need to have so that their experts can help them prepare a defense in this case. Now, there's actually going to be 2 hearings in this case, and that's going to be this Thursday. At the second, which will not be open to the cameras or the public, the defense intends to present evidence and witnesses related to the IgG DNA. Now, IgG is the investigative genetic genealogy, which was used to connect DNA found at the scene to a family member of Bryan Kohberger. Now, this IgG is often used to solve cold cases, and some people think it's controversial. As critics argue, it's a violation of the Fourth Amendment right prohibiting unreasonable searches and seizures. I'll talk about that in a second. But the defense has asked 2 witnesses to testify via Zoom, a woman by the name of Leah Larkin and Bicca Barlow. Now, in February, the judge granted Larko and Barlow access to the IgG material in the case while keeping the information sealed to everybody else. Now, Barlow is an attorney who focuses on DNA cases, and in previous court filings, in the Kohberger matter, Barlow said that she has consulted on more than 200 cases as a DNA counsel or consultant. In that filing, Barlow said there has been a history of misuse of the IgG database by law enforcement. And she alleges that the law enforcement and the genealogists have sometime engaged in what she refers to as deceptive practices. In the motion, it states it is imperative in the defense in this case to know how Mr. Kohberger was identified and who else in his family tree might have been identified as a subject of the investigation. That's in the pleadings. Now, she said the defense wants evidence of what was uploaded to the database and any other potential matches. Also expected to testify is Leah Larkin, who is a genetic genealogist. In a previous filing in that case, Larkin said she is aware of the chain of custody failures in other cases and security loopholes where law enforcement has bypassed rules and privacy restrictions. Argues that the access to the data and the methods used in this case is necessary to determine if the investigators followed the rules and policies of both the Department of Justice and the genealogy databases. Like I said, the hearing is mostly sealed as it relates to the IgG DNA stuff, so we won't get that information until much later in trial or perhaps in a pleading that'll sneak out to us. Anyway, as you may recall, back in April, the defense argued that the information related to the procedures should be made public. Now, the defense also alleges that the prosecution and the FBI want the information hidden because what the FBI did violates its own rules and the rights of privacy as it relates to the genetic genealogy companies that they promised in their disclosure agreements. Now, the prosecutors argued against releasing much of the IgG information, partly because the state says it used more than just that to identify Kohberger as a suspect. Remember, when he was arrested in Pennsylvania, investigators then swabbed his cheek. Now, the prosecutors say that the swab matched the DNA on the knife sheath found at the crime scene. This is a very interesting issue. So what it comes down to is that is there a Fourth Amendment violation? Even if the FBI violated their own policies and procedures, that's normally not enough for it to somehow be thrown out at a hearing. It simply goes to its weight, not its admissibility, right? The jury can give it whatever weight it believes is necessary, but it's coming in. It's ripe for cross-examination. Closing argument. They didn't follow their own rules. As it relates to the genealogical people, the government action is saying, hey, can we have access to your records? And the genealogy people saying, yeah, here's our records. The real beef should be people saying, why are you turning over my information? Well, they want to find out who their relatives are in their ancestry, all that kind of good stuff. They don't read the fine print. They don't think that it's going to be used to help solve a murder. Who knows? Maybe they want it to be solved a murder. But it's not like the government is getting something that they couldn't get basically voluntarily from the people who said, hey, would you give us this information? These companies roll over and they do this for them. The companies are the one, like I said, should have a beef as it relates to their clients saying, we're going to keep this information and we're not going to give it to the police. It's no different than when you sign up for everything on your phone, the apps, the free Google, email, all those types of things. They're saving your information. You are the product. And in the genealogical situation, I'm sure they're going to create this database and they're going to sell access to it in the future. You, once again, ladies and gentlemen, are the product. You're not the customer, you're the product. Your information, they're going to sell to you, no different than Facebook or Google sells their information to all their advertisers. This case, it just happens to be the police. So I don't think it's going to be a big issue. It's going to be cross-examination. And the big issue in the Bryan Kohberger case is the DNA. As we've talked about many times, that's right, because, well, your lovable CrimeTalk host is probably the only blogger or whatever you call yourself on YouTube these days, creator that has his own K-bar that he just happened to have since the end of summer of 1988. But yes, this is the little sheath, this is the little button on the sheath that allegedly had Bryan Kohberger's DNA. And we'll give him the presumption of innocence, but I'm telling you, the only thing that is going through the defense attorney's mind at this time is, I have to be able to explain that DNA. You can say all the other stuff, oh, the ID, the car, whatever. I'm telling you, from a defense attorney's perspective, it's that pesky DNA. And if you can't explain how it got there, you've got big trouble. So I wish the hearing was going to be televised for all to see, but you know how it is. We just can't handle this all this sophisticated information that the court wants to keep from us. It's not going to affect the trial in any way. Like I said, any other trial in the country is an open courtroom. You could go in and you can watch. Is it going to affect a fair trial? No, it's not. Let us see what the heck is going on. And besides, we're probably going to get to hear it on cross-examination anyway, so what does it matter? Anyway, next on the docket, Alec Baldwin. That's right, he didn't get his case dismissed. Oh my gosh, I'm so shocked. No, I'm not. Okay, this is the classic thing. If I had $1 for every time a client said, well, when are we going to file my motion to dismiss? And you say, well, under what basis would you like to file a motion to dismiss? Well, it's for lack of evidence. They lied. Okay, well, that's a question of fact. And the judge has already found that probable cause exists. So now we need to go to trial. That's what it is, you know. But every client thinks they're going to file this magic motion to dismiss. It doesn't exist, ladies and gentlemen. The people who file motions to dismiss are prosecutors. You can file them as a defense attorney, and they get denied, just like Alec Baldwin his. So the judge in his case rejected Mr. Baldwin's attempt to dismiss the sole criminal charge against him in the fatal shooting on the movie Rust. Obviously, now the case is on a trial track. So Judge Mary Marlowe Summers Friday upheld an indictment charging Baldwin with one count of involuntary manslaughter in the death of cinematographer Helena Hutchins back in 2021. Here it is. The judge rejected the defense arguments that the prosecutors flouted the rules of the grand jury proceedings to divert attention away from exculpatory evidence and witnesses. The judge rejected that prosecutors acted in bad faith after reviewing transcripts of the grand jury proceedings, noting that the prosecutors are not required to present exculpatory evidence. The judge even noted, New Mexico law does not require a prosecutor to present exculpatory evidence to the grand jury or require a grand jury to even consider exculpatory evidence after alerted to its existence. Now, the judge acknowledged that some questions by the grand jurors were deferred to a hired expert witness for the prosecution, but she said that didn't prevent the jury from making an independent determination in coming to the charges as it relates to Mr. Baldwin. Now, there were arguments last week on the motion to dismiss, and it went on for about 2 hours or so, and the defense attorneys for Baldwin accused the prosecutors of cutting off questions from the grand jurors and making little to no effort to communicate with defense witnesses in case they were called upon. Shocking. Anyway, the prosecutors have denied accusations that the grand jury proceedings were some way illegal or improper, and they say that Baldwin made a shameless attempt to escape culpability, highlighting contradictions in his statements to law enforcement, to workplace safety regulators, and in televised interviews. Anyway, the decision by the judge removes, this motion that was pending, and now the trial is set for July. Now, Mr. Baldwin has maintained that, yes, he did pull the gun's hammer back, but he did not pull the trigger It went off by itself. Anyway, Mr. Baldwin was pled not guilty to the involuntary manslaughter charge, which carries 1.5 years in prison. As you may recall, last year, the prosecutors dismissed an involuntary manslaughter charge against Mr. Baldwin after being told that the gun he was holding might have been modified before the shooting and malfunctioned. A new analysis of that gun last year enabled prosecutors to start the case anew. Anyway, prosecutors have turned their full attention now to Mr. Baldwin after the judge in April sentenced the co-defendant, that's right, the weapons supervisor, Hannah Gutierrez, to prison for 1.5 years, the maximum penalty. So, Mr. Baldwin's case not going away. Let me tell you, ladies and gentlemen, we've all heard the phrase, you can indict a ham sandwich, okay? Yes, you can. It's literally that easy. The grand jury, I mean, hypothetically speaking, if one were to have gone into a grand jury proceeding. Now, in where I practice in state court, you can go in and you can sit next to your client if he's in the grand jury proceeding, but you can't advise him, you can't ask any questions of him, and he can't ask any questions of you. Federal, you can't do that, but I have been in the grand jury room for other reasons. Anyway, the prosecutor, let's say he has a case. Let me give you an example of how this works. The grand jury usually meets once or twice a month, made up of these 15 to 25 people. They are the grand jurors. They meet once a month, usually for 1 day, and they literally have a schedule. And depending on the case, they can issue subpoenas, they hear testimony, and they hand down indictments, a true bill. And a prosecutor may say, let's just say a simple gun case, and say, police officer, what happened? We went to arrest this guy. When we did arrest him, he had a firearm on him. Okay, did you find out that he was a previous offender? Yes, we did. Have you confirmed that through records that he had a prior felony conviction, therefore he would be prohibited under the law to possess a firearm? Yes, we did. Very well. The prosecutor then will hand a indictment to the grand jury foreman, who will then sign it and then have all the others sign it. Boom. You have been indicted by a grand jury. You have no right for exculpatory evidence to be produced at the grand jury, just like you have no right, say, for example, in a preliminary hearing, for the judges to consider affirmative defenses like self-defense. It's just a screening process. Can a grand jury say no? Yes, but they rarely do. They are a rubber stamp for the government. So don't be appalled when you get indicted, ladies and gentlemen. Your story will not be told there. That is for a trial. I get it. Nobody wants to go to trial because they're scary. You could get convicted, so you want to get it dismissed. But this motion to dismiss, weak, okay? Just like I think the whole issue in the Bryan Kohberger case as it related to the grand jury stuff. Weak, okay? Save your time, save your energy on things that matter, like defending your client in court. Next on the docket, a San Diego police officer got himself into a very embarrassing situation. So here's the skinny on this, all right? Maybe if he was a little skinnier, though, he could have fit through a window and climbed out, but he couldn't. Anyway, a San Diego police officer can be seen in some newly released body cam video actually locking himself in the backseat of his police car with a female suspect who wanted to have sex with him, before he actually had to call a colleague of his, a fellow police officer, to come get him out of the car. So here's the guy, Anthony Hare. He resigned from the San Diego Police Department after investigation into this little situation was launched, and just 1 day before he was to be interviewed by superiors. Now take a look at this video. It starts after he's arrested the unidentified woman because she was suspected of stealing a car back in August of 2023. Now, the suspect, she is wearing the tank top and red shorts, was one of 2 people wanted for the car theft, but she had a bench warrant out for her, so she got arrested. Anyway, the officer, Officer Hare, was to take her to the police headquarters and then to the detention center. As they drove back to the police precinct, the woman is heard propositioning the police officer for sex. She asks him, "Hey, you married?" The Officer Hare says, you're not too bad. What's it going to hurt me if I'm working the system? You know what I mean? That's the way I see stuff. She then asks, are you single? To which he responds, yes, but you're not. Her shocking response, I'm down to effing right now. Officer Hare, resisting her temptation, says, "Don't say that right now. Don't say that right now because everything is being recorded right now." As they continue toward the detention center, he can be heard asking her what she's doing in the back seat. Hare then started driving his cruiser down a residential street, according to the GPS, and coincidentally, his body cam got turned off. Imagine that. Some 20 minutes later, however, he had to call a fellow police officer, stating that he had locked himself into the back of the patrol car. Ooh. Apparently he had to beg the colleague to come help him, asking if he had a master key. And the officer described the good officer, Officer Hare that is, as somewhat panicked as he was in the back seat. The unidentified officer said, "I asked him if he was okay. He said yes, and then I asked him if I had my patrol car. I asked him why and what did he need." The officer said if he could go meet him. I asked him his location, and he said near Cottonwood. I asked him why he needed, and he said he would tell me when he got there. He said he was really embarrassed. Shortly thereafter, the police get there to the scene. They open the back door, discover Hare and the woman together in the back seat. By the time he's been found, the officer had been locked with the suspect in the back seat for roughly an hour. Now, of course, Officer Hare denied anything happened with the passenger in the back seat, repeatedly saying that he was checking on the suspect when the door accidentally locked on him and that the camera shut off because he knocked it off its clip. The good officer, Officer Hare, stated, "When I was waking her up, that's when I noticed that this door closed me in. That's when I was trying to kind of open the door," he said. Shortly thereafter, the police get to the scene, open the door, discovered Hare and the woman in the back seat. So, needless to say, the police department went as far as trying to do their investigation, asking Officer Hare to do a reenactment of how that door could have possibly gotten closed and how his body cam video could have been turned off. Needless to say, he was supposed to go back in front of the investigation to complete his statement to the higher-ups doing their investigation, and he resigned instead, hence the reason why the body cam video has been released. Take a look at it. Do you really think that was an accident? Yeah. And, they found some stuff on his duty belt as well. How did that get there? Next, maybe when somebody famous dies, somebody will actually take notice. So the man that was shot and killed during an attempted, wait for it, catalytic converter theft in downtown Los Angeles on Saturday was identified as an actor by the name of Johnny Wachter, W-A-C-T-O-R. He appeared in about 164 episodes of General Hospital between 2020 and 2022. And he also appeared in a bunch of other shows. Anyway, his death was confirmed by his brother, and it's reported that the LA Police Department responded to the area of Pico Boulevard and Hope Street at about 3:25 a.m. on Saturday morning. When they arrived, guess what? They found the actor suffering from a gunshot wound. Police said that the man saw three men stealing the catalytic converter from his car. When he went out to confront them, they turned around and shot him. Now, the man, now revealed to be Mr. Wachter, died at the hospital, and no suspects have been found. Now, the actor's wife blamed his death on the weak on crime policies in L.A. I'm sure this is going to take a little bit of time, but they will find these three suspects, and they will all be charged. But maybe, just maybe, because it's somebody that's semi-famous. I never heard of the guy. Haven't watched General Hospital in probably 35 years. But maybe that will finally draw attention as to what the heck is going on and the lawlessness in so many states. Next, the world's most arrested man has passed away. Henry Earl. God bless him. That's right. He has a criminal history that included at least 1,500 arrests. Anyway, he passed away last week. He was 74. Now, for the last several years, Earl just kind of slowed things down a little bit, and he resided in a nursing home in Kentucky, and in the Kentucky area is where he got most of his arrests. Now, it's reported that Earl was regularly arrested for public order crimes fueled by alcohol and booked into the local detention center over the years. Now, when they stopped counting the number of arrests that he had spent 6,000 days in the county lockup for offenses like public intoxication and disorderly conduct. Violent crimes, not so much. A lot of public intoxication. Anyway, take a look at these mugshots over the years. Pretty nice, huh? Anyway, according to the records, Earl would usually spend several days behind bars before being released back into the Lexington, Kentucky streets. And Earl was first busted back in July of 1970 for carrying a concealed weapon at the time. And then over the following decades, his rap sheet became so lengthy, it threatens to deplete U.S. timber reserves. Now, before Earl went into the nursing home, he had a few longer stints in custody when the judges grew tired of his drunken exploits. Anyway, Earl passed away Earl's last arrest was back in April of 2017 for public intoxication. Anyway, he was laid to rest on Thursday. Doesn't look like anybody showed up for his burial from his family or anything like that. Probably from all those years of public intoxication. Nobody wants to hang out with him. Anyway, you got to admire that. 1,500 arrests. I had a client once that he was trying to get out of custody, and the judge noted that he had, like 76 failures to appear. And he acted like it was no big deal. And I'm like, no, let's not talk about that. And anyway, the judge is like, sir, you have like 76 failures to appear. Most people don't go to court 76 times, let alone have a court appearance and then fail to show up for it 76 times. Needless to say, the judge denied his bond, citing that he was a flight risk and likely not to appear in court. The judge was right because he posted the bond and immediately failed to appear. So what can you do, ladies and gentlemen? Some people, they just have their own personal records out there. Earl had one, and, well, my client had one as well. And then finally, our dumb criminal of the day. A Florida woman was arrested Tuesday night after allegedly striking a man in the neck with, wait for it, a cinnamon roll. That's right. Police allege that Anne Marie Luna chucked the food item at the back of a 49-year-old victim, striking the victim at the base of his neck. The cinnamon roll incident occurred at the St. Petersburg, Florida Transitional Housing Facility. I think that's referred to as a halfway house. Anyway, the arrest affidavit does not reveal the motive of the alleged cinnamon roll attack, which was recorded by security cameras. Of course it was. Anyway, after being read her rights, Miss Luna admitted to tossing the cinnamon roll. Now, the officer's further investigation, it is noted that they did not seize the weapon. The cinnamon roll did not injure the victim, but he did wish prosecution of the cinnamon roll chucking defendant. Anyway, she's been charged with misdemeanor battery. Miss Luna was booked into the county jail. After spending a night in jail, she made a $500 bond. Obviously, she can't go near the victim. All right, ladies and gentlemen, that's all we have for you today. I hope you enjoyed the show. Please remember, join us 6 p.m. Mountain Time tonight. We will go live, our Tuesday night live program. And immediately following that, we will do our Patreon show as well. So please join us. Thanks for watching, and we'll see you next time on Crime Talk. And remember, yes, the Constitution does matter.